Welcome to the mediation session on engaging the disengaged. It's one of the application of pro bono mediation launched by Asian International Arbitration Center. Before I begin, let me check what's the most important question in the minds of the commercial entities, which is how to get the opposing side to agree for a mediation forum. There are instances where the contracts also provide for mediation as one of the options for dispute resolutions. Yet there are parties unwilling to engage in mediation and would rather wait for the claiming party to commence legal proceedings, either through arbitration or court litigation. In general, the parties know that mediation is a consensual forum, so unwilling party is not in a hurry to agree for a mediation. Such a perception is flawed in present context and future developments of ADR forums. I'm going to share with you briefly three aspects of engaging a disengaged party. First, mediation is a moral obligation to humanity. Legal framework for enforcing mediation clauses and settlement agreements through national and international mediations is catching up. Number three, the benefits of unsuccessful mediation. There are financial benefits. We can agree to disagree. Let me go through these one by one. First of all, on the premise that the party initiating a request for mediation believes first in these moral obligations to humanity. First, remember, you need to love your neighbor like yourself. The question is, who is your neighbor in a business context? Obvious answer would be the contracting party to a contract from which a dispute has erupted. The next question is within your belief system. It doesn't matter which faith a key stakeholder or a party is from, it's in the core of every faith and scripture and doctrine that settling disputes is not a service to mankind, but is also pleasing to God. It's not only a service to mankind, but is also pleasing to God. If you resolve one dispute in a month, all the sins of the year can be washed away. Love your neighbor like yourself is the first commandment. Settle your disputes with an adversary before the sun sets. Looking at the Luke 12:58, when you go with your adversary to the magistrate, make every effort along the way to settle with him. Lest he drag you to the judge deliver you to the officer, and officer throw you into the prison. Also through Takim and Sul in Sharia, the Prophet in his well-known commentary mentioned, should I inform you of something that is higher in virtue than fasting, praying, and charity? And they said, yes, O Messenger of God. And the Prophet said, to make reconciliation between people that are in conflict. And the hadith of the Prophet also affirms that every peace, sul or sulah as we say, is permissible except the one which makes a prohibited lawful or vice versa. So remember, sulah is making peace, shalom, or agreement between the parties. So if the moral obligation or the spiritual obligation is not convincing enough for engaging an uninterested party, then we need to reason with them by explaining the latest developments in mediation forums. For example, there is no need to incur legal costs by engaging lawyers. For complex construction contracts, it may be advisable to seek legal advice and get limited help to formulate your strategy for mediation, but not necessary to bring your lawyers to mediation session, though they can be standby outside the mediation chambers to provide support and advice during the mediation session. Secondly, in view of the noble initiative launched by AIAC, which is the first of its kind in the world for commercial disputes, there is no need of the mediation center and the mediators. There is no cost of the mediation center, and the mediators are also freely giving their time due to their spiritual obligations to humanity. Next, explain the reluctant party. Let us meet to refine and fine-tune our disputes. It is not forced upon anyone to agree for a settlement, but at least the parties should know what their legal and contractual issues in dispute are. Explore the options. Default provisions and pitfalls for party unfamiliar with arbitration can also be explored. If that is not convincing, if the cost incentives of the pro bono AIAC mediation is not convincing enough, then look at the law. There are court sanctions imposed by courts and arbitration tribunals if a party does not respond or unreasonably refuses to participate. In the last 2 decades, since year 2000, there have been several cases. I just give you a snapshot of a few cases. In the English Court of Appeal case in 2013, there was a landmark ruling in which the Lord Justice Briggs said that silence in the face of an invitation to participate in ADR is, as a general rule, of itself unreasonable, which is echoing the English Court judgment of 2001, in which Justice Lightman said, very clearly, the party refusing to mediate may be penalized in costs. The party who refuses to proceed to mediation without good reason may be penalized in courts, although mediation is not compulsory. In Singapore courts, this has been practiced for a long time now. Where the compromise between the parties has been reduced into consent judgment, the general principle is that the court will not interfere to set it aside after it has been made and perfect it otherwise than on grounds of fraud only. So moving on quickly, the next legal provision is in the standard form contracts for staged or tiered dispute resolution processes, which makes it legally binding sequence to be followed, or contractually binding sequence to be followed. In order to promote international trade, several institutions, governments have been working hard to promote mediation. Some of you may know already that in year 2013, Department of Justice of Hong Kong launched the Mediate First Pledge and invited parties across the region to sign and make a commitment to resolving dispute through mediation. Thereafter, a contracting party, before entering into a contract, will be obliged to fulfill its pledge to go for mediation. WIPO also launched an initiative in 2018 for IP-related disputes. And now AIAC has taken a giant step forward by not only asking the parties to mediate first, but opening up its facilities and services for free or very low cost, including provision of pro bono mediators, which is first of its type for commercial disputes. Furthermore, United Nations Convention, UNCITRAL has rolled out an enhanced convention in support of enforcing settlement agreements achieved through mediation. This will encourage parties from 53 countries across the globe to come forward in the spirit of mediate first. One can draw a comparison between Singapore Mediation Convention and New York Convention. New York Convention is already ratified by 167 countries, and there is a considerable trust in the enforcement of international or foreign arbitral awards. while Singapore Mediation Convention 2018 is still quite fresh from the oven, but is changing the landscape of ADR forums at a faster pace. In context of all these developments in the international legal framework, it will be difficult to stay as an uninterested party or unengaged, refusing to engage. Now I will touch on the strategies during the process of mediation, how parties can benefit. First of all, do your homework, get external help if necessary, engage claims consultant and or legal counsel to help in developing various options, keeping in mind that in litigation there are uncertainties. In mediation, you have a choice on the type of outcome you wish to achieve, unlike in litigation. Develop your BATNA, best alternative to negotiated agreements. What is best for you given the factual situation of your case? BATNA, what is preferred alternative? You may not achieve your BATNA, but at least you should know what you would prefer and settle for. If you don't settle for BATNA or PATNA, what is the VATNA, worst alternative to negotiated agreement, will indicate your position. For example, you will get to know what are your legal costs outlay to start litigation or arbitration. Suspension of works, payments will be stopped, and loss of future business and or reputation. Finally, NATNA, this is the best or the least benefit one can get out of a mediation process. Non-negotiable items as an alternative to negotiated agreement. So during this stage, identify the issues which are in dispute. Come out with the outstanding issues. Some can be settled. They need not be carried forward into arbitration or litigation in court. Quantum in dispute can be roughly estimated here. Performance obligation, which one to stop, which one to continue performing. No need to stop everything. Items agreed, subject to resolving. Some of the VOs or items could be agreed. Variation orders could be agreed, but they are not agreed because there are major ones outstanding. So there is a dispute on others, but those which are agreed, which can be agreed, are also pending. So this is an opportunity to resolve those if possible, otherwise identify them. And finally, this is the best outcome. At least you know where you are not disputing. List of undisputed facts. According to another school of thought, if a settlement agreement is not achieved, parties may still be satisfied in one form or the other. Substantive satisfaction if you get some outcome. Procedural satisfaction that you have gone through the process, you understand where the parties stand. Socio-economic satisfaction. You have fulfilled your pledge to mediate first, compliance to your contractual obligations, if it is a contract clause, and psychological and emotional satisfaction. And that's very important. Only in mediation you can scream, shout, and tell the other party whatever you want, whatever you wish to say. Parties can understand each other's feelings and how far one is willing to go in case you proceed to litigation or arbitration. You get to understand the way the other parties perceiving the dispute and how you perceive the dispute yourself. Maybe there were some misconceptions or misperceptions that can be resolved. There's nothing wrong for prudent commercial parties to agree to disagree. This can be termed as a mediated settlement agreement of disagreements between the parties. At this stage, parties may like to involve their solicitors to fine-tune the issues to be carried forward for arbitration or court litigation. However, parties must retain control to ensure that small matters or small value claims could be resolved to avoid disproportionate costs of arguments by attorneys. For example, if a claim is of 10,000 and involves too many supporting documents, evidence, legal arguments to prove, a party may consider that as a secondary issue or resolve it with discounts. Just go to litigation arbitration with limited number of issues. And there are possibilities to have multiple mediation sessions on certain issues, specific issues. You can discuss the issues which cannot be agreed for mediation. In mediation, they can be settled through arbitration, but there are certain issues which can be discussed. Cost issues, you can resolve. You don't need to spend chargeable hours, paid hours on all these items, which is purely on a quantum and can be substantiated and agreed between the parties. With that, I recommend a suggested model clause as in AIPN. You can choose a choice of your own choice dispute resolution center and put it in this blank space, for example, AIAC. And you can fill in the blanks in terms of number of days and who to appoint the mediator. These things can be done in the early stages or during the contract formation. And then put on clause, settlement agreement shall be governed by United Nations Convention on International Settlement Agreements resulting from mediation. Parties to opt in according to Article 81B of the SMC. In case the state declares such a reservation, it shall apply this convention only to the extent that the parties to the settlement agreement have agreed to the application of the convention. And settlement agreement shall be enforceable as a judgment or as an arbitral award. Remember to include these two clauses. And if dispute is not resolved through mediation within a certain number of days, after the request of mediation or such time, then only you should initiate arbitration. And I wish you all the best. Thank you for your attention.